All rise. The Court of Appeals of Bishop Wood is now in session.
Thank you, folks. Have a seat. Good morning. We are here in 1 CACV 220664, Sunland Materials LLC versus Flood Control District of Maricopa County. We are here for oral argument. Each side has 20 minutes. You will be arguing from the podium, as is our return to tradition. The clock is visible from the podium. It does count down from 20. Counsel, if you wish to reserve time for rebuttal, that is on your responsibility. You're welcome to tell us, but we will not keep track of it for you, and so your full 20 minutes will show. Before we came here today, we have read the briefs, we have conferenced the case and discussed it thoroughly. We're familiar with the issues. So you do not need to restate the briefs for us. Each side does have 20 minutes. You don't have to use the entire time, but please use the time that you feel you need to. With that, we are also live recording and broadcasting these proceedings. So when you do approach the podium, please state your name and identify your client for the record. So with that, counsel, if you're ready.
May it please the court, I'm Robert Porter. I represent Sunland Materials LLC. I will reserve time for rebuttal. I think I can boil down the briefs to this issue. Was the variance between the charges, the allegations set forth in the March 10, 2021 letter, and what Sunland Materials was fined for sufficient to set aside the daily fine that was assessed in the end? The variance also violates principles of fairness, surprise, and notice, and for those reasons as well, it should be set aside. The rule of law is that a party should be put on notice of what conduct is being charged. Here, the letter that starts the proceedings is March 10, 2021, and in part, it begins, activities performed on the subject property are in violation of the floodplain regulations. And then it describes the activities, including excavation of soil material and grading, not in compliance with the permit. And it goes on to say it is unlawful for any person to engage in any development not in compliance with the permit, and cites the statute and the regulation. The statute it cites is ARS 48-3615, and capital A is the particular section. It says it is unlawful for a person to engage in any development. And then it adds, or to divert, retard, or obstruct flows. And then it goes on, in any development without securing the written authorization required by another statute. And then it says, where the water course is in a delineated floodplain, it is unlawful to engage in any development affecting the flow of waters without securing written authorization. That's the statute. The regulation cited is much the same in section 708, capital A. It talks about a class 2 misdemeanor engaging in any development in a water course without first securing the written authorization of the district, or to divert, retard, or obstruct the flows of waters in a water course. And why does Sunland say that there's a variance? Because here, the flood control district is not resting on activities that occurred for the 111 days for which we were fined $1,000 a day. That fine was based on the time of the letter, March 10, 2021, until the permit was issued on June 29,
So,
2021.
Can I summarize your argument? Your argument is basically, as long as they don't catch us while we're doing it, and we stop once they catch us, they can't fine us? That seems to be your argument.
No, it's not all my argument. My argument is...
Well, this argument that you just raised, we were not mining at that point, so therefore, even no matter what we did beforehand, we're not actively doing it, so there's no fine that's appropriate.
That's not my argument at all. My argument at all is charge us with what we've done. We admitted we mined outside where we should have. We admitted that. And if they fined us for the days that occurred, we would have no argument. My argument is the flood control districts, and they have full control of its charges. That's not what they charged us with. They said cease and desist and go get a permit. We did both.
You didn't get the permit for 111 days. You could have done it long before. You waited and your client, I should say, not you. Your client waited and waited until a fine came in to even try.
And I've explained that, why there was confusion between the parties, both the flood control district and Sunland Materials, about what the permit, what parcels were permitted to be mined on under the previous permit. So, yes, we could have earlier, but we didn't because
We're not here to reweigh the evidence on confusion. So the work not in compliance with your permit, your client was advised that the work was done that was not in compliance, and it had continued on the site, and the hazards have only increased. Now, I grant you, and I'm not going to go back and forth on whether your client eventually stopped, but during the discussions when this was happening, your client was continuing to cause the work to be done outside the permit. And the district has performed a number of site inspections, and your client was told that the way to come into compliance was to get a permit, so it's on the parcel, and to obtain a permit in order to remediate the site. Now, your client had the other option, which is to put it back, to actually remediate the site, but the easiest one was to get a new permit. It was your client's decision not to do that with this March 10th letter. And before that?
My problem is, to restate, my problem is that what they charged us with and what we got fined for afterwards were different. It may be like the Carlson case, you may want to say, for all the reasons you just advocated, that it's the right result. But what I'm saying is it's the wrong reason because of...
So how is it... At this point, when the fines were instituted, could they fine your client for anything? Under your argument?
They could fine us for the conduct that was alleged, for that conduct that was alleged, for excavating and grading. They could have fined us for that, identified the period of time, and fined us for it. I have no problem with that. That's.
But the violation was the property condition at the time. When they issued this, the property was in a certain condition that your client had altered that was in violation of the law, and your client had a duty to remediate it. One of two ways. Put it back, and rebuild the mountain, put it back the way it was supposed to be, or get a permit.
You just hit the word condition, because essentially that's what the district is fining us for, is the condition. The condition...
So your argument is your client can't be fined for the condition it created at that point. I mean, it just seems to me you're going, fine us sooner, but you can't fine us if we're not actively mining.
I'm saying fine us for the conduct that you've alleged. Don't fine us for something we condition which you don't put in your letter or in your charges anywhere.
Your client was surprised to get a fine? Is that what you're saying?
For the 111 days. Let me put it differently. Had we known we were going to be fined, because we applied for the permit before all this started, had we known...
And you never got, your client was denied because there was an error and your client never fixed it.
Oh, no, I'm sorry, Your Honor. I didn't communicate clearly. We applied for the permit, I think, on March the 8th. I think the previous permit ran out on the 1st. And so what I was saying is we had applied, but here's my point.
But you had, under that previous permit, your client had been mining in violation of that permit.
We admitted that. There was no question. I'm not trying to shade that.
Okay.
But what I'm saying is that had we known we were going to be fined for the condition, then we would have sought a variance right away. We would have asked for the flood control district to expedite our permit application. Because
am I understanding that your argument is because no one brought the hammer down on us, we can never get the hammer? Is that, and we won't try and fix it until the hammer is down? Is that what you're saying?
No.
Okay, then walk me through this.
My principle is the same principle that was in the Carlson case we've cited. There, an employee was cited for sexual harassment. And in the end, it was a sordid proceeding, as described by then Judge Timmer. It was a sordid proceeding because the employee that was being harassed, they had had a sexual affair. And what the hearing officer did in that said, I don't find you guilty of sexual harassment, but I find you guilty of violating the standards of conduct. You're fired. And the Court of Appeals reversed it and said, no, that's not what you charged the employee with. What you charged the employee with, you found there was no grounds for. You suspended him for grounds that were not alleged in the charges.
But counsel, the violation was digging on property that your client did not have a permit for. That was the charge.
Understood. But we weren't digging for the 111 days that we got fined $1,000 a day.
No, but the property continued to be in the condition in which your client left it by its misconduct.
But the condition was not the charge. From what I just read in the letter...
Do you have any case that draws this distinction between condition that says if the condition, you can leave it in this horrible condition as long as you're not actively doing it? Any case that supports that?
The statute and the regulation itself support that it's the activities that are being fined, not the condition that's afterwards. If you want to continue to use the property, you've got to get a permit.
So your argument is, basically, if you don't catch us while we're doing it and we stop when you catch us, you can't fine us under the statute.
No, it's not a law. I've said from the beginning, charge us with what you're going to fine us for. Don't say X in the charge and fine us for Y.
So the Carlton case you were talking about, there are two distinct things there. There's the sexual harassment and violating a policy. Here, your argument, and you want to draw a distinction between the mining and the excavating and say that that can't carry forward to the condition. Is that your argument?
My argument is the charges were the activities including excavation and grading, and they were fairly described, and that was all that it was limited to. And we ceased and desisted when we got the letter, and we had applied for the permit beforehand. And so why should we be left to however long it takes to get a permit to determine what the fine should be?
This wasn't a surprise. Again, you keep focusing on that, but your client knew well in advance that it was in violation. This discussion had been ongoing, that there was a violation on these I'm going to use the 4 properties at that time. So I'm a little lost why you say, well, this is just fine us for what you said, when your client is aware for years that it should have gotten a permit. In fact, tried, didn't get it because it put the wrong name. And then just ignored it.
The surprise is the difference between what we were charged with and what we were fined with. Okay, the client had, the permit history is what it is. There was not a permit application that was denied. The professional engineer, Len Erie, was working with the flood control district. So there wasn't an application in between the expiration of the present one then, which was March 1, 2021. There wasn't a denial between that and the permit that was issued. It did get issued in due course. And I'll reserve the rest of my time for rebuttal. Thank you.
May it please the court, Wayne J. Peck. I'm a deputy county attorney and general counsel to the flood control district, and with me is Sean Moore, also a deputy county attorney. Those people who know me can attest to the fact that I am rarely at a loss for words, but I have no idea what it is I'm supposed to say to you in this circumstance. The standard of review is, does the record support what the flood control district did? I think that's clear that it does. Again, council has admitted they violated their permit. So it seems that the argument is that somehow we didn't tell them that what they did needed to be fixed before they would be in compliance. And the notice of violation clearly states that there are two parts. The argument that's being made to you was made before the hearing officer, before the Board of Hearing Review, before the chief engineer, before the trial court, and they all rejected it, saying you don't come into compliance by doing half of what it is you're told to do. I believe the panel understands that.
What about the argument, counsel, that they applied for a permit? So, as I understand counsel's argument, Mr. Porter's argument is, number one, we were asked to do two things. We were asked to stop digging, and we were asked to apply for a permit. We did both immediately. And then the argument goes, because we did both said things, we can't be fined, although the property continues to be in violation, in a violative condition.
Well,
What is
first,
the response to that argument?
well, the first is that the remediation, the notice of violation did not say apply for a permit. It said obtain a permit. The permit itself required that if you wanted to renew the permit, you file 6 months before the permit expires, not 7 days afterwards. So, as Judge Goss indicated, had they applied timely, they would have had their permit by March, and none of this would have happened. And again, Judge Goss is correct. What the argument is if you catch me and I stop, that's all I have to do. The notice of violation clearly told them what they had to do, and also reminded them that under the statute that until they did it, every day was a new violation punishable by fine. I don't think I have anything else to tell you, but I'm happy to answer any questions you may have.
Well, I guess I'll jump into this. I mean, I'm struggling a little bit, counsel, with some of the same things you're struggling with, but I think that there's two aspects I sense in his position for why they think it's a due process argument. And one is that it's kind of ex post is what he's saying. He's saying we did something wrong, but that was before. So, you know, I'm stuck with that. I'm holding this bag of stuff I did wrong. And then there's kind of a scaling thing, which I don't think he's really saying expressly, but it's kind of interesting to me. Like, is there a number of days after which the scale of this would become so disproportionate to the underlying that it could be a due process issue? I mean, $1,000 a day, you get to $111,000. Well, what if it took a year to get a permit? You know, can the county fine you $2 million for something ex post that you did when you're starting from the moment of that notice to fix it? I mean, is there any possibility of a due process issue in the machine there or no?
Your Honor, because you touched on something that raises my hackles, I'd just like to point out the county is not fining anyone. It's the flood control district, which is a separate entity.
Sure.
But to answer your question,
My apologies.
it's a common mistake. To answer the question, no, I don't believe it becomes a due process issue because control over eliminating or ending the fines was 100% within the control of Sunland. By statute, the flood control district has adopted and published timelines by which we must issue a permit. When there are delays, it is because the applicant is told, you need something else, and they take their time getting it to us.
So your argument entails that a 6-month period is reasonable, so if you find out you did something wrong, basically the entity that I misdenominated a minute ago sort of has a per se right to fine you $180,000 is kind of what I'm hearing, because that's 6 months, right?
No. 6 months, you're supposed to apply for your permit 6 months before your permit expires.
No, I get it.
So
if
had
you
they-
started at the end, it takes 6 more months, and I do the math, that's $180,000, right?
However much time it takes, and that's what they were told, excuse me, by the hearing officer recommended that there be a penalty, and the penalty was imposed in April, so they knew about it while they were going through the process.
See, the reason I agree with you at this point in your argument is because there's notice that they created a condition that needs remediating. So they're sort of on sort of the bad actor side of the ledger where some sort of punishment is due. It would be a due process issue if they had no notice of that and they didn't have notice of the fine. He's trying to bootstrap the idea, well, I didn't know I was going to get fined, into a backwards, I didn't have notice of the underlying thing. And since they caused the underlying thing, I kind of don't get the argument at this point. But I do have a problem if the fines start stacking up into the hundreds and hundreds of thousands of dollars and you didn't see it coming. Here, I think they probably saw it coming. That's why I tend to agree with the tenor of this discussion.
I appreciate that, and yes, had we said your violation is that you excavated, stop excavating, and then we had imposed a fine because the property remained in an non-compliant condition, I would agree. That, to me, is the case that's been cited. That's not the situation here. We told them that. When you dig a hole in the riverbed, you divert water. That's a violation. We have to review that to make sure you're not causing damage to others. That's the charge by statute and the regulations. They had ample notice of what was going on here. One of my complaints to my client was, why did you wait so long to bring these people in? Part of it was when we finally were ready to move, COVID hit. So that's the period there. But they knew since 2019 that they were digging under the wrong plan of development and did nothing about it. And Judge Goss, you're 100% correct. If all you have to do is stop, why would anybody ever follow the regulations? I'll just go out there, hope I don't get caught, and if I get caught, I'll stop. Now what?
So conversely, if Sunland had restored the property to its pre-violative condition, that would also mitigate the ability of the district to impose a fine, would it not?
Yes, but I will admit that in order to fill in the hole, you need to get a permit. Because you can't just willy-nilly fill in the hole. We have to make sure that it's being properly done so that it doesn't divert flow from the river. It's not like a bathtub where you just put the stopper in and now everything's good. There are serious consequences to what goes on in the riverbed. The whole idea of these regulations stemmed from federal legislation that was then passed over to the state, and the state of Arizona requires every county to have a flood control district. As you know, these are serious issues when we get the rains we get. Theoretically, yes, and they could have probably obtained that permit more quickly, but they wanted to continue to operate. They needed to get a permit.
That's how we got the Salton Sea, was somebody digging out a channel in the Colorado River they weren't supposed to dig, and boom, the Salton Sea is restored to existence. But so is that the same duration for permitting in Judge Faria's question that you just answered? Would it take 6 months, or is it some different scale of time to get the permit you would need to get to remediate, which is one of their two paths out of this mess?
How much time it takes to get the permit is very much in the control of the applicant. If the applicant's engineer comes in with a plan that we can approve, then you can probably get the permit in under 30 days. But the problem is too often, in most cases, I don't know about the flood control district, but I'm hearkening back to when I was in private practice representing developers. Too many times the engineer who is reviewing finds issues with the engineer who submitted the application. Often it's something like, okay, this is what you say is the result, show me the work so I know that it's correct. So I can't give you a timeline, but you can obtain a permit quickly if you do your work correctly. And Your Honor keeps saying 6 months. I believe this was 4 months.
I was referring back to your answer about the guideline being you're supposed to start 6 months in advance, and I presume from your answer that you meant that they could have accomplished the permitting in the 6-month period before the fine started.
Oh, absolutely.
That was an implication I drew from your answer. I'm sorry.
No, you're correct. And in this case, they did. They obtained it within 4 months, which they could have done many years before.
Or at least the 6 months before, if they had just followed the prescribed rules, which is apply for your permit 6 months before, at 111 days, they would have had the approval and no fines would have occurred.
Yes, if they had submitted the same application that was approved by the district.
You mentioned that there are deadlines and that the flood control district needs to follow. What is the deadline once an applicant submits an approval? And you're probably, from that look, may not know the answer.
Well,
and that is okay, but I was wondering, what is the deadline once there is an application that is complete?
okay, well, there's the administrative completeness. I represent many departments and agencies that have timelines, so I will represent to the court that it's somewhere between 45 and 60 days. And then you have the substantive review, which also would be between 45 and 60 days. But I do know from personal experience that the district usually turns those around very quickly. Understand, it's not our goal as a flood control district to fine people. It's our goal to make sure that properties comply with the regulations so that we don't have to worry about people and property being destroyed when we get the torrential rains that we so often get here in Arizona.
So I just want to, if they had applied 6 months ahead of time, some time for administrative, but 60 and 60 at least puts it at the 4-month range, and a 2-month buffer, and it still, again, could have been accomplished without the fine.
It could have, Your Honor, yes. Because that's what they were told. The record shows that many times they were told, apply for a permit, apply for a permit. It wasn't until that never happened that the district finally decided to issue the notice of
And
violation.
actually, I just want to, they were told to obtain a permit.
In the notice of violation, but prior to that, the inspectors, and there are representations in papers from both sides, that there were meetings
Yeah.
among the parties, and they were told, you need to get a new permit, get a new permit, get a new permit. They didn't do that. That's why the NOV came out and said, until you have your permit, you're in violation, fix it. Thank you.
Thank you, counsel.
Bob Porter back again for Sunland Materials. Let me address 3 issues. On the timing of an application for a permit, the regulations themselves set out a table and classify what you're doing in terms of a permit and put timelines of 30, 60, or 90 days. So the timing of the review of the flood control district is set forth in the regulations. It's not a hard and fast time period, but at least they give you an indication if it's a new permit, here's what can be expected for the different reviews and the total days. That's set out in the flood control district's regulations themselves, that timing. The second point that I want to address is even the flood control district was not convinced that we could be fined for the condition. And the reason why I say that is the chief engineer and the general manager of the flood control district, Mr. Vogel, went out of his way in his final decision in order to say that we continued to operate. even beyond the April evidentiary hearing, as a basis for the fine. So if it was clear to the flood control district they could fine us for condition, the chief engineer and general manager did not believe it by the terms of his final decision in order.
Excuse me, what page of the record is that, and were you still operating?
We were not still operating, and the final decision in the order, I'd have to find it.
Okay.
It's there in the appendix.
Okay, but that's the final decision on order,
Yeah,
he says that.
final decision in order.
Okay.
That was following the hearing officer's recommendations. And it was the hearing officer who made the recommendations about the retroactive fine. I bring that up because the flood control district at the hearing didn't say anything about what they wanted, didn't say a word. In fact, didn't say that we were diverting waters, didn't say anything. They had one witness who talked about meeting with Sunland Materials. That was their case, and some exhibits showing where we had mined. That was the extent of their case. Nothing about condition, nothing about diverting. That was it. So it was a surprise to Sunland Materials to get from the hearing officer this retroactive fine for condition. Wasn't asked for, but that's what came out. If we were in a criminal setting, I don't think the court would have any problem. You can't charge somebody with X and then convict them of Y.
But, counsel, we're not in a criminal setting.
I understand, but
We're so far away from that standard that I don't know that the analogy is helpful.
well, okay, I apologize for it, but I'm reaching for an analogy because if you're told, cease and desist, go obtain a permit, and you do so, and then you find out you're going to be fined for the condition of the property, I think that's an unfair surprise. I think that violates due process.
But
If that's
your
what
client
you-
admitted that they dug where they were not supposed to dig. They knew that that they had created a violative condition. So, and they knew that for months before the notice of violation came out. So I'm struggling to see how Judge Goss's characterization is not apropos. What you're saying is, I didn't know, but what you're saying is, I didn't know that I could be punished for doing what I've been doing, although I knew that it was wrong.
Well, I think the short answer to that is then fine us for the time that we were engaging in the activities that you cited us for in the letter. Cite us for that time. Fine us for that time. At least it's consistent, because it's unfair for us to walk into a hearing thinking that's what we were being charged with. We ceased and desisted. We had applied for a permit. Oh no, because it's intentional and you knew what you were doing, we got you still.
But counsel, the excavation continues to exist. Whether your client actively is doing it or not, your client created that. The diversion continues to exist. It doesn't take an active effort on your client's part. Once it's violated the permit, the other things that continue. And your client is aware that it's going to get a daily fine when that happens. So I'm struggling with how your client is just dumbfounded and surprised that there would be this fine.
Well, I'm struggling when dealing with your conclusions because I think it's fairly clear, at least from where I stand representing a client, that you ought to fine me for what I'm being charged for, not fine me for something that resulted from what I did when that wasn't what I was charged for.
But the thing that's missing in the logic, for me, counsel at least, is that you call it, and I quote, a retroactive fine, but you're in a sense being fined for prospectivity because you're being fined for the continued existence of a violative condition you created in the past, like my brothers here said, but you have a path to remediating that through applying for a permit, like we just discussed with other counsels. So why isn't it prospective instead of retroactive?
Because that's what the hearing officer's recommendation said. That's what the order said. That's the final decision in order. Retroactive back to March 10, 2021. That's what it said until the permit was issued. And I'm out of time.
All right, thank you, counsel. We appreciate the argument, and and we'll take the matter under advisement and issue our decision in due course. We are adjourned.